Hi, folks. It's Denise Howell. This week on This Week in Law, we have the Big Apple. It's dominating in the corporate arena, and in the legal arena, who knows what's going on with all its patents? Well, Matt Macari knows, and he's going to try and help us understand it. Facebook gets into more legal trouble while Twitter doesn't. Also joining us, Ben Snitkoff and Evan Brown. Stay tuned for This Week in Law.
Netcasts you love.
From people you trust.
This is TWiL.
Bandwidth for This Week in Law is provided by CacheFly at CacheFly.com.
This is TWiL, This Week in Law with Denise Howell, episode 83, Making Flour at the TWiL Mill. Hello and welcome to This Week in Law. I'm Denise Howell, and we're here to talk about all this week's development in the fun and ever-changing world of technology law. With us to do that today are Ben Snitkoff from technicallylegal.org. Hi, Ben.
Hi, Denise.
Great to have you back on the show.
Great to be here.
Thanks for bringing the brownies.
Thank you. Yeah,
we'll enjoy those. Also joining us is Matt Macari from, now tell me if I'm pronouncing this wrong, Matt, Suing IP Law or Some IP Law?
Some IP Law. It's a clever take on our first letter of our last names.
There we go. Yes, I did get that. Matt is both a patent person and a Mac lover, so we have some great stories that cover both those topics to go over today. And also back on the show is Evan Brown. Hi, Evan.
Hey, how's it going?
It's going really well. Good to see you again.
Great to see you. Thanks for having me.
Always a pleasure. Of course, folks, Evan is at internetcases.com and practices law at Hinshaw and Culbertson in Chicago, Illinois.
That's
so,
right.
Because we have a couple of Mac aficionados on the show today, Ben, I understand you're a bit of a Mac head yourself.
I am.
It's been quite a big week for Apple, so I thought we would jump into some stories about our friends with the Macs and the iPads and the iPhones and all of the wonderful devices that make our lives so much more fun and interesting. They've had a fun and interesting week with their earnings call on Wednesday, which Nilay Patel, another fellow friend of TWiL, called the most insane earnings call we've ever been on. They announced record earnings, revenue, and sales. They're now the biggest U.S. company, is this right, behind ExxonMobil, valued at $274 billion, with
Wow.
Exxon out there at $331 billion. So not really a legal angle to that, but I just thought it was super interesting from a business standpoint that the company with these insanely great products, but still, notoriously small market share has managed to turn that market share into what we saw this week. It's really quite impressive. And any thoughts about this as it affects Apple's other dealings in the business world, including its legal dealings, Matt?
Well, I mean, I guess it shows a successful product, a lot of successful products. Whenever I read through that article, and the thing I thought of first was that I had a friend back in the 80s, early to mid 80s, who had quite a bit of stock in Apple, who sold it off during the late 80s when he was converging over to PC world, and I bet he's regretting it now.
Yeah, absolutely. Every time I sell Apple stock, I regret it. It's usually a temporary period of not regretting it and then a long-term period of regretting it.
Well, I just can't find a period now to buy it. It's just too tough.
Exactly. You have to buy the tiny little fractional shares as with the big Goog.
Yes.
If you can find a way to do that. Evan, any thoughts on this?
Just be interesting to see if, the security issues with, the operating system. I guess this has been true that oftentimes, malware, seems to not make its way into that computing environment because of the small market share, not worthy of the those script kiddies time, to develop malware for that. So it'd just be interesting to see transitions along those ways. Is the platform actually going to become less secure because it's a more worthwhile target for that kind of stuff? That would be what I'm intrigued by.
Yeah, that is an interesting idea. And maybe Apple will say, hey, everyone's always said it's because we had our small market share. It's actually because we actually understand security. Yeah. And we're keeping you guys more locked down than you would be in other environments. What do you think, Ben?
I think that, not to foreshadow too much, but as Apple becomes a bigger monetary target, they're going to face more litigation, both patent litigation, which is, I think, something we're going to talk about a little later, and other types of lawsuits. It's, the bigger your cash reserves, the bigger your product share, the bigger the target is on your back.
Yep. Excellent point. Well, apparently Apple's got a target on its back right now in this Mirror World case that could take $1.8 billion out of its $274 billion valuation. Matt, can you tell us what's up in that case and why the proposed damages are so astronomical?
Well, it's interesting because a lot of the articles and things I read about it originally were focusing on the $600 million damage award. That's based on infringement of 3 of the plaintiff's patents.
Start from square one and tell us what the case is about.
Well, it's focused on the cover flow features of various Apple products. Oddly enough, I went through some of the pleadings and things like that in the online actually, but you can't get to most of it because it's almost all under seal. Anything interesting that you want to read is under seal. But so they were found to infringe, and by the jury, and the jury awarded $200 and some odd million per patent, which by itself is a little unusual because it gave each patent, which is probably related to the same invention, the same amount of award damage. So what happened at the end of the day is they found them to infringe, and they found them to infringe willfully. And that's a relatively big deal. It could be a big deal. It could mean absolutely nothing in the end, but it at least allows the judge now, or forces the judge, to take on briefing and figure out exactly whether or not those damages can be tripled, which is in the statutes for patent law. Infringing is one thing. Willfully infringing is a completely different thing. And with that comes the possibility of the judge tripling the damages.
So this is about the cover flow feature that you see in iTunes, whether it's on your computer or iPad or other device. Can we talk for a second about how something like that is patentable? It seems more like a design feature than, a mechanics kind of feature that could be subject to a patent. Can you flesh that out for us, Matt?
Well, on either side, there are a couple ways to patent things, especially in this area. One is you could go after the, and this is the way it's probably done in this particular case, and I haven't looked in detail at the patents, but they are focusing on the user interface, and it's a software method type of procedural claim. Maybe we should clarify that you might have a lot of broad, nice, clever descriptions in your patents and titles and things like that, but what it really comes down to is the claims in your patent. And if those claims are directed to something like this, they're likely directed to methods of flow. It's a visual. It's a visual, almost like a flow chart. The claims would follow like a flow chart where you'd see the actual method in which the computer itself or the device or hardware utilizes the screen output and shows you exactly how the various, in this case, cover art or things like that in iTunes are transitioning across the screen.
Right. Ben, have you taken a look at this case? Do you think they're really going to be facing down $1.8 billion in damages?
There's always the chance that the judge would reduce the verdict, either if all of the patents are related and determines that they didn't really all deserve separate awards, or if the judge, like in what we saw in the Jeremy Thomas case, just thinks that the jury's verdict was unreasonable and unsupported by law. But if you look at it, it is a huge verdict, but $1.8 billion is 4% of Apple's cash on hand. So Apple could pay this off and not care.
Do you think that given that they would try and settle this thing and make it go away?
I wouldn't be surprised if they tried to settle it for something substantially less than $1.8 billion. But if the plaintiffs are really holding out, my guess is that they'd either appeal the decision or try to get the judge to issue some sort of remittitor and reduce the damages.
Evan, did you take a look at this?
I did, and I guess $1.8 billion would be nice to have, and even if it's 4% of Apple's cash on hand, the way they're doing so well, they could probably just put this on a credit card and earn it out in the next few years. Obviously,
maybe an iTunes gift card.
A wonderful idea. And, what is it that we're talking, $200 and some million?
274. Oh, I'm sorry, you're talking about something else.
What were for each patent? I'm looking at the verdict form here, and it was $208.5 million for each one, without the willfulness enhancement, if you will. I mean, if somebody were to write me a check for $208.5 million, I wouldn't just let that check, sail out of the open car window. So come on, isn't it a little bit silly to be thinking about, taking this up to $1.8 billion when we're talking about these large astronomical figures? I hope that common sense comes into play here somewhere, and there's a reasonable settlement, and we don't have to get into all this nuanced stuff about willfulness, looking back at the record and all of that stuff, figuring out whether they should enhance it. They've got to figure this out and move on to better things. I really hope they do.
I think you're right. I think it's just as likely that the damages will be reduced than increased to $1.8 million. If it's $208.5 million per patent, and I've heard some commentary on this, that and you have to be there, I guess, dealing with the judge and the briefings that have taken place along the way. But it sounds like there might be some openness from the judge to look at two of the patents as, sort of just an improvement of the main patent, which might justify reducing that amount so you don't get the equal amount of the equal damage award on each patent individually, so it doesn't add up to $6 million. So it may be reduced down to $200 million or something in that range.
Right, and I think you introduced the notion of some uncertainty. I don't know if we would call it ambiguity, but some uncertainty and I think maybe you mentioned it already on the show here, as to what technology the patents really pertain to and whether there's a certain amount of overlap, right? Wouldn't that figure into a calculation of actually reducing the award, or would that be kind of an apples and oranges type of thing when we're talking about liability versus damages?
Yeah, it's very relevant, because often these patents, and I don't know all the details of these patents, but you'll have a parent patent or a grandparent patent, and what you'll have is these continuations, these new applications that are filed that are relating directly back to that patent. So they're variations on claim scope, but they could be essentially based on the same invention. So, and I don't know what the stats are on this, but it's pretty common to treat them as a whole, or at least to combine them so that you don't have these individual awards, $200 million award on each individual patent. You kind of group them together and take it as a whole.
Well, Matt, I'm going to ask you to do something here that I haven't ever seen somebody comprehensively do. So you have our indulgence in advance if it's simply not possible. But in this world of all the mobile patents that are flying around and all the lawsuits between Apple and Motorola and HTC and all the rest, can you try and make heads or tails of that for us and let us know where things stand now and what we should be looking for in the future as far as any concrete impact on the actual mobile platform or business?
Wow. That's well, I can tell you it's interesting because there is this there's original suit, and there's more than one, I suppose. Apple's suing HTC for patent infringement relating to the iOS system. And the droids. I mean, it's focused on the Droid OS. And they chose HTC, and I don't actually know why, other than it's a size issue. You go after certain people first, and then certain companies, and then you move on to other competitors. But they have now been sued by Motorola preemptively. Apple's been sued on those same patents. So Motorola's thrown themselves into it voluntarily and preemptively brought suit to invalidate the patents. And I'm sure that pretty much every patent crosses over into the HTC, the Apple versus HTC case. And
so wait, they're not seeking, let me interject here, they're not seeking to say that they did not infringe. They're not asking a court to make that determination. Oh, they are.
They're doing both, and it's pretty standard. If you're going to file a declaratory judgment action, it's pretty common in patent cases. Settlements break down, people, or they get some sort of threatening letter. It doesn't take much to actually qualify for there are some threshold requirements before you can file suit against a patent holder to say your patent's invalid. I don't infringe your patent. But in this case, my understanding is there was some sort of talks going back and forth, and perhaps they broke down, and Motorola decided to go ahead and preemptively file suit rather than waiting for Apple to come after them.
Okay, Ben, any thoughts on what this stew of back and forth patent litigation about phones is going to do to that industry, if anything?
As an initial matter, I was kind of surprised that any of this started. I had always operated under the kind of assumption that all of the big players would stock up these patents as a kind of mutually assured destruction to make sure that nobody filed suit against anyone else, because, you know, the resulting litigation would just be, you know, crippling. It would be huge. But, you know, now we've got Apple suing HTC, as you mentioned, Motorola suing Apple. I think Microsoft has sued Motorola, and there was actually a Flickr chart, a chart that somebody uploaded to Flickr that, you know, draws out all of the lines, all the connections here. And I mean, who knows when we're going to start seeing actions on these, be it you know, motions for summary judgment, or if somebody files something in the International Trade Commission to try to get products to stop being imported. But really, I'm just surprised that all the companies finally pulled the trigger and are going to risk being shut down or having, you know, massive fines imposed on each other as a result of, you know, all of these patents that they've been stockpiling.
Evan, do you think that that's a realistic option, that we might see something in the ITC, the International Trade Commission, blocking imports from China of various phones into various countries until this is all sorted out?
Well, that would really be kind of a rough remedy. That seems like it would really be disruptive to the economy of things here. I would think that if that were, you know, to happen, it wouldn't be. Nobody would suffer that to last, that state of affairs to last for too long. So that would be, I guess, also an incentive to figure out how everybody's going to coexist in the same universe and figure out some kind of licensing arrangements between all of these behemoths of participants in the marketplace, so that there can be some kind of equilibrium established in the industry, you know, that one would expect to see in any kind of new area of technology after a certain amount of time for things to settle down. I think before we've talked about this, and some people are talking about this in the chat room as well, comparisons with this and the you know, the early days of the you know, the desktop operating systems, you know, with Windows and some of the features of that there was some real uncertainty as to the copyrightability of those things. And so one way or another, there's going to have to be some kind of stasis achieved here, and what actually would serve as the motivations for the achievement of that stasis would be something like what you're talking about with the ITC, and just natural time for things to kind of shake out however they will. So we'll see some kind of more certainty coming around the bend, I'm sure.
Yeah, I agree.
Yeah.
I really was
Matt.
surprised. Oh, go ahead.
No, give us your final wrap up of these patent issues.
Well, I was really surprised also because, you know, the idea of mutual destruction is pretty common among these large companies, and I don't really see the exit strategy. And because I don't, you know, I don't know, I don't have a long history or knowledge of the various Apple suits, patent infringement suits that have taken place over time, but they don't appear to me to be the kind of company that's going to be willing to license their technology. And so maybe in the end, it's about, and don't forget that Motorola is also sued Apple previously for patent infringement and recently. So it's more than just people infringing Apple's patents. There might be an opportunity for cross-licensing. I just don't know what it is exactly that Apple, because the thought of it actually shutting down these other platforms, these other OEMs, to me seems far-fetched.
Okay, well, we will have to see what happens there. But I mean, the thing that obviously people get nervous about is that their favorite platform or whatever is going to be impacted by this sort of internecine battling between the players. And, certainly nobody wants that to happen. So I hope those folks will keep it in mind as they try and work out their legal kinks. Somebody who's no stranger to legal kinks is Facebook, and this week is no exception. Presently, their hot button issue has to do with apps leaking user data, something that they have had concerns about from the get-go, and now it seems that those concerns have blossomed into a lawsuit. And as facts come out about it, the folks in Washington are starting to get concerned, and Congresspeople Ed Markey, who's a Democrat, and Joe Barton, who's a Republican. So we found something that the parties can actually get behind in a bipartisan way, is that apps leaking user data are not a good thing. They've written to Mark Zuckerberg and are trying to figure out what's going on here. Evan, what is going on here as far as the Zynga lawsuit goes?
Well, there's a new suit filed in California this past week that alleges, I haven't read the complaint. I didn't look real hard for a copy of it, but from what I gather, reading of the article, it alleges, at least among other things, violation of the Electronic Communications Privacy Act, sending, data that's in transmission between, various entities, various parties. I guess it would be the communications between Facebook and Zynga, that data being made available to third parties. And from what I gather, the allegations are that Zynga is doing this voluntarily, actually selling some of the information, which doesn't really sound like a good idea, and as much as that is also a privacy breach. But I'm really not surprised at all to see these lawsuits. I guess, well, there's that California case, and then there's, the complaint is at Rhode Island. There's a case that's been pending for several months, and that complaint has been amended to, add, some facts that deal with this more recent Zynga thing. The California case goes just against Zynga, but the Rhode Island case also actually is going directly against Facebook, presumably not doing enough to keep this leaking of information from not occurring. I'm not surprised about this at all. I mean, the Federal Trade Commission, has as we know, looked into, the privacy practices of Facebook. There's been a lot of scholarly literature that talks about some pretty bad types of information leaking that occurs, that sounds much worse than what we're hearing about in this Zynga case and in the case against Facebook in Rhode Island. It's all just a matter of being able to take information from disparate places and piece it all together and develop a profile in the generic sense of what a user is all about and what they're doing here. So there's nothing at all to be surprised about in seeing litigation like this arise. And I'm surprised we haven't seen more of it already, actually.
Yeah, I mean, where Facebook is concerned, they seem to face these issues all the time. Ben, do you think, obviously we're concerned about it. Congressman Markey and Barton are concerned about it. Do you think anybody's stopping their Farmville or Texas Hold'em games in light of all of this?
I think the people who are concerned about Facebook privacy have already taken steps to deal with Facebook privacy. We had the wave of people a few months ago who are quitting Facebook, and every time Facebook introduces a new feature, I know I go on and I disable the feature to the best of my ability. It's really all we can do at this point. I don't think I have any apps installed anymore. So the people who are at least aware of the issue, I think, have the tools to deal with it. It's in the cases like this where the apps or Facebook is exceeding what they've said they'll do or what they say, the apps are allowed to do, that you're going to have problems. On a side note, Ed Markey and Representative Barton are the two people who sent Apple a letter a few months ago, if you remember that, asking Apple to explain the location services as it related to serving ads. So they've got a history of this bipartisan privacy concerns.
Yep, good for them. I guess when you receive your letter from Representatives Markey and Barton, you better be ready to have a good response. Matt, any thoughts on this?
Well, I have a question. And I've, like many people, I'm sure, I've tried to go through some of the security settings in Facebook and find it convoluted and difficult to find some of these things. But is this something that would occur regardless of what settings you have? It's just if you run these apps, it's automatically bringing in and collating this data for use?
From what I understand, it's information that Zynga has, from Farmville users and users of other games, information that they have by virtue of their access to the Facebook platform as a developer and application provider. And so it's what they're doing with the information that they presumably have, pursuant to authority under the developer agreement, with Facebook. So it would be independent of your privacy settings, so long as you have opted into, you decided to use the app and play the game or however you want to characterize it. That's my understanding of it.
Okay.
Yeah, what this is emblematic for me of is that Facebook's instincts along these lines seem to be just wrong on most fronts. That, when given a decision whether to make something opt-in or more secure rather than less secure, they always seem to err on the side that disturbs people, which is disturbing. Ben, you were talking about when new features get rolled out, you make sure that you're as opted out of them as it seems necessary to be. The new social search with Bing, there was some discussion with Mark Zuckerberg about how it's exposing the world of people's likes within Facebook and on other sites where they click the like button in a context that they possibly didn't expect. But the response there has been, well, if you're liking something, we think that the culture and the assumption there is that that it's going to be public. And so, the fact that it shows up in search shouldn't be any real big surprise. But, for them to make leaps like that, it's just really astounding. They took the whole like framework with Friendfeed when they purchased that application and platform and brought it in-house and then farmed it out on the web. But I think that people's expectations, I think that sometimes when people are using like buttons, they're almost using it like a bookmark feature. That maybe they think they're just compiling, a list for themselves, and maybe their close friends who they've monitored and made sure, is a limited universe within Facebook for seeing things that they want to keep track of. And then to shift the context on them and put them into Bing search results, it's just, yet another thing that Facebook makes an assumption that I don't think the users necessarily would go along with. Evan, what do you think? Am I being too persnickety about all this?
No, I agree with everything you said there. I think that's real accurate evaluation of Facebook's approach to it. But at the same time, I believe that a lot of this has to do with the difficulty that users have in extrapolating the consequences of what decisions they make and what to go click like on. When you read an explanation of how the social layer that Facebook has added across the web now is supposed to work, it's easy to understand in concept when you read descriptions about it, but it's difficult to imagine each of the various ways that the fact of your expression of some kind of preference may be exhibited in a number of different ways. And to be honest, I guess with incorporation into the Bing search, that's news to me, that has happened. So I guess, I'm just confident now that the social graph and the social layer across the web will be okay when Y Connect, Yahoo's competitor to Facebook Connect, is launched in a little while. That'll just make everything all better, right?
I think it'll make things more confusing. Yeah, I fear anyway that it will. Right. What do you think, Ben?
I have to agree with you, Denise. In the rare circumstances where I've liked something on Facebook, I really don't mean to broadcast to the world that I like that. I'd rather that not show up in people's searches, and for that reason, I don't remember the last time I clicked like on something. Because there's this, who knows? I've got a lot of friends on Facebook who I haven't talked to in a long time, and frankly, I'd like to communicate as little as possible to them. Yeah, no offense to some people who were very nice to me in high school. I just don't need to share my life with you anymore.
I think it's crazy to assume that because you understand that there's some level of it's a public forum that you automatically make that leap that it's going to be public, basically in perpetuity. I mean, when you do something on Facebook, you do it within a confined environment, and you intuitively put some sort of half-life on it. I mean, you don't expect that it's going to be out there forever. And regardless of whether or not you thought really deeply about what you're saying or whether you've pushed the like button, it's a little crazy to just assume that because people are involved in that and are engaged in it, that they're somehow signing a waiver to have everything come up in a search completely unrelated, who knows how long down the road.
Yeah, the example I was thinking of, and I think I heard it on Twig this week in Google earlier this week. I don't know. I listen to all the Twitch shows, and they tend to blend together. But the example was the way the Bing search is going to work is it's going to deliver you not just search results, but also things within your social network, like Google's search does, but it doesn't interface with Facebook. So the scary example someone came up with was, so say you're searching for a disease, and somewhere along the way, one of your friends clicked like on a page about that disease, and suppose they did so with this, sort of bookmarking intent and not meaning to broadcast that, but just to sort of keep track of the page. All of a sudden, in your search results, you're going to see that your friend also is interested in syphilis or whatever it might be, which could be really kind of strange for everyone involved. So I don't know. Once again, Facebook's just got to struggle with these issues, and I think, as Ben said, caution is a good watchword when using the service. For people who are just done with being confronted with like buttons and the whole world of Facebook Connect, it's interesting that someone has actually come up with a Chrome extension called Facebook Disconnect that will just wipe your Chrome browser of any of those cues. So if you don't even want to be tempted, apparently that came out this week. Let me see, where can you find the story on that?
Is that somebody that was actually somebody at Google?
Yes, it was.
Yes, it was a Google engineer. Here we go.
Are they angry at the fact that, does it have a little something to do with the fact, I'm assuming it wouldn't work out the same way if Bing hadn't announced a partnership with Facebook or Microsoft with the public searching or the Facebook link to.
Yeah, this is from Alexia Tsotsis over at TechCrunch. Let's see. Google engineer Brian Kenish, inspired by the most recent Facebook privacy and data debacles, decided to create Facebook Disconnect. God love their 20% time. Love it when those Google engineers get to just go do something fun and useful. So that's out there if anyone just wants to be able to turn off all that connectivity. And then the last thing I wanted to talk about on the Facebook front this week is that we've tried to talk about social network on the last couple of shows. And so let me just take my poll. Anybody besides me on the call yet seen the movie?
I have.
Ben's seen it. Okay, good. We have someone.
I have not. I haven't seen it.
Okay. Not Matt. And Evan?
My life is too lame, I guess.
Yeah.
Well, I got a 5-year-old. I just can't find it. I can't convince him to go see it.
Same here.
Evan even promised on last week's show that he would go see it this past weekend. We're so disappointed in you.
I had placed a half-life on that information. I didn't know that was going to come up a week later that I had made that promise.
Right. Well, so the last thing I wanted to bring up was that Eduardo Severin wrote a column over at CNBC and gave his take on the movie and very much took the high road and, didn't get down into whether it was accurate or inaccurate. Just said that it was somewhat surreal to have your life depicted on the big screen and hoped it influenced others to go out and do entrepreneurial things, because he hoped that one of the messages that came through of the movie was that in today's day and age, we live in a time when great things can happen with small resources. Ben, why don't you give us your take on the movie and its various legal overtones?
I thought it was a great movie to watch. Aaron Sorkin, as always, is just a master when it comes to dialogue. And Denise, I agreed with you in that I was sitting there going, it's like a deposition, but it isn't a deposition. I was trying to figure out, and my understanding is that what they did is piece together those conversations from several depositions. So my guess is some of them were depositions of Eduardo Severin, some of them were depositions of Mark Zuckerberg, and some were depositions of the Winklevoss twins. And then they just kind of spliced it all together so it would flow a little better. But in general, it was a really fun movie to watch. And
all right.
Yes, there were probably at least a colorable
Don't you think someone will sue?
Comes to Sean Parker.
Yeah,
I doubt anyone will sue. It's a tough claim to make, and most of the people who are depicted are public figures to at least some degree. I agree that Sean Parker would have the best claim as being just painted in a unflattering light, but he's got enough money, and what's he gonna gain by suing at this point?
Maybe he actually likes being associated in the national eye with underage sorority girls. Who knows? Maybe that's sort of a boost.
I actually I do want to see it. Whenever I hear somebody talk about it, I wonder, because the internet wasn't as developed at the time that this other movie came out, but back when the Pirates of Silicon Valley came out, obviously it didn't paint a very good picture of Steve Jobs, right or wrong. And was there a discussion much back then, the same kind of discussion about how truthful it was, accurate, the depictions it gave of the characters in real life?
I'll disagree with you in that I think it didn't paint an unflattering picture of either Steve Jobs or Bill Gates. Steve Jobs even invited Noah Wyle, who depicted him in Pirates of Silicon Valley, on stage for a Macworld to do the introduction. And at the time, I don't remember any conversations about libel suits, but again, that movie did not portray anybody in a particularly unflattering light. It showed Steve Jobs yelling a few times when Bill Gates ripped him off, but it was probably accurate.
It didn't show him participating in various illegal substances, etc.
There was, now that I think about it, I think there was one instance where it showed him on LSD.
And
the situation with his daughter, Lisa, that was, whether it was truthful or not, it wasn't the most flattering.
Yeah, I think it's a pretty interesting notion, making a movie or a book about someone that's living and not giving them the opportunity to weigh in, respond, participate. I don't practice defamation law, but just things about this movie rubbed me the wrong way in that regard. But I'm not them. So one company who is a service that we all use, everybody increasingly uses it all the time to the point of ubiquity, is Twitter. And yet, where we had the discussion about how the instincts, the decisions at each crossroads with Facebook too often go to the side where people are concerned, Twitter seems to have unerring instincts along those lines. And Evan, you recently did a video about Twitter and the law, and I just found it really interesting that as we discuss the various controversies about various big technology and web services each week on the show, we're hardly ever discussing Twitter getting in trouble. We're discussing how Twitter can be used to get other people in trouble, because they have this instant communication channel that is so easy and available to everybody in any location, really. But Twitter seems to keep its nose clean. What do you think, Evan? Are they just more savvy about these things? Did they make some smart choices at the beginning as far as having the social dynamic be that everything was going to be public? How is this?
Well, no doubt they're savvy over there. They've got really smart people. They've always had really smart people, both on the engineering side and the business side, and obviously in the legal side as well. So savviness plays a big part of it, but even in larger proportion is just the simplicity of the platform. I mean, good grief, all it does is allows you to post little messages of 140 characters after all. So, what is it that they can really do to get in trouble? They don't, allow a lot of robust user-generated content to actually be loaded onto the system. They don't provide, any content themselves. Obviously, advertising has, to date not been a big part of it. I guess we may expect to see more of that. So really, they're just not doing anything themselves to get in trouble. And a lot of the discussions that we've had about complications that Twitter as a company could have, from providing its service have been largely academic. I wrote maybe I, unconsciously kind of went searching for some of these issues back in November. I think it was November of 2008. I wrote a blog post about, opining whether Twitter is itself a copyright infringer because it took such a hands-off approach in its terms of service, its old version of its terms of service, saying we don't claim nothing about your content, no rights at all. When you tweet something, I was saying, well, obviously they have to exercise one of the rights of the copyright holder just to publicly display the tweets, and so if they're not claiming a license to do that, they don't have a license, and therefore when they do it, they're infringers. But that was kind of a silly thing. That was kind of a time waster looking back on it. That was kind of I don't know why I wrote that blog post.
Academic exercise.
Yes. I mean, it was just whatever. So, the real interesting things come about from how the users interact with one another on Twitter, whether they be accused of defaming other people or, engaging in some kind of trade libel. There's been some litigation here in the state courts of Illinois in Chicago where the woman put up a tweet talking about how her apartment realty company doesn't care that she had mold in her apartment. She was sued for defamation for that. There's been, of course, the Courtney Love case. I think Perez Hilton, wasn't he involved in some litigation for some stuff he said on Twitter about Kirstie Alley? So there's really nothing to look at Twitter itself as a platform for in terms of its legal responsibility or things that it can do to give rise to liability. It's all the stuff that individuals can do to one another, defaming one another, otherwise harassing one another, doing whatever, and the harm that they can do to themselves, through the goodwill of their brand, either talking about their own, using Twitter for public relations and marketing and stuff like that, the harm that they can do by saying, things that cast their company in a bad light, or engaging in some kind of false advertising by saying erroneous things about a competitor. That's where the real, a possibility for legal issues in Twitter to come about.
What do you think, Ben? Do you agree? Is Twitter above the fray, and it's the rest of us who are making things messy as far as that platform goes?
I mean, as far as the Communications Decency Act, Section 230 has them covered pretty well as far as anything that's said on Twitter. And as far as the privacy concerns go, I mean, Twitter has always been very upfront about unless your username is protected, unless your account is protected, everything's public. And there's nothing they can really do to change that. I seem to recall some controversy when they first started doing search as to, whether or not people thought that you'd ever be able to search the entire database. But other than that, it's been pretty uncontroversial because, there was a switch and it was either public or not public, and that's the way it stayed. I mean, the only other thing that I remember being remotely controversial about Twitter is when Foursquare started posting location updates. There was the Please Rob Me site, which, as I think we mentioned, should have been called Please Burglarize Me.
You know,
right.
I don't know, maybe some of it has to do with how, at least for me personally, how I use Twitter. And a lot of it's based on my interests and the things that the companies I follow, the people I follow, based on my profession or my hobbies, and less personal for me. So there may not be as much overlap with the personal. I mean, obviously people are using it for things that talking back and forth, but it seems to me it's more about interest-based. I gather the information that way. I don't use it so much as a personal connect like I do on Facebook.
And it's very distinct, you know, when you're liking a link or a page in Facebook. There, you know, it's a mystery, I think. It's an open question, you know, what the ramifications of that are. Are you doing it just for yourself? Are you doing it just to share it? It's such an ambiguous act to click that like button. But when you're pointing to a link on Twitter, that's not ambiguous at all. You're putting that out there because you think people should see it, and you're telling them to go take a look at it. So good for you, Twitter, for keeping things comprehensible for your users and for making them be the troublemakers. Other troublemakers in the news are folks in California, a website called Note Utopia that was allowing students to buy and sell class notes in the California State University system. And what is going on with them is apparently there is a provision of California law that prevents you from making commercial use of class notes and things in the California state school system. So I bring this up because it's interesting, I think, from both a copyright standpoint and also from a free speech standpoint, that you could have a state telling students or telling this business that they're not able to operate based on their business model. Evan, what do you think of all this?
2 words, Section 230. Yeah, I'm surprised Mike Masnick didn't pick up on that when he wrote about it, you know, because this is how I found out about it in the links, you know, for today's show, his post over on TechDirt, which, of course, supplies so much grist for the TWiL mill. What's happening here is students who are arguably, I think we can, you know, safely assume, are creating their own works based on, you know, the content that they're getting from their professor. They're taking notes. They are transferring those into some digital format. If they're not originally taken, I forget, you know, I've been out of school long enough that I'm not fully cognizant that most students use laptops in class now. You know, sharing that content on a centralized platform whereby others can search and find it and purportedly utilize that material. Section 230 says that no provider of a service like what Note Utopia is doing should be treated as the publisher or speaker of that content. And this California statute prohibits, you know, the preparing, selling, transferring, distributing, publishing of this stuff. And Section 230 also contains a provision that says any state law, you know, contrary to the provisions of Section 230 shall be preempted. So I cannot see how Net Utopia could face liability for violation of that statute if it is just merely providing the platform for third-party information content providers, namely the students who are uploading their stuff to use the system. I just don't see how they could be running afoul of this. Now, the students themselves, I guess, could be liable, perhaps, and that question of liability is even separate and completely removed from whether they might be violating some kind of academic code that they have agreed to abide by. But as far as going after Net Utopia, that's a loser right out of the gate.
Yeah, I'll start off with, I'm not a copyright attorney, but it doesn't make any sense to me. To me, I look at it like you would if somebody was writing a review or making notes or commenting on a piece of work they were a song they were listening to or something like that. Are they arguing it's a derivative piece? I mean, I'm not really sure. I don't see where the liability comes off of this, because it's just their perception of something they're hearing. It has nothing to do, as long as they're not copying, pasting in excerpts from the PowerPoint that the professor's using. I really see what the issue is.
Right.
Yeah, I don't know that they've come out and stated an overt, this is infringement of the university's copyrights kind of position. They seem more concerned with people building a business out of things that should be happening in purely the academic realm. That seems, as I read the article here and the statute that it discusses, that's what I'm gleaning from it.
My worry is that, and I think you alluded to this, Denise, that the statute may be unconstitutional. It seems to be pretty coextensive with copyright, and the federal government has exclusive jurisdiction over copyright. And any state law that tries to, establish some kind of copyright, which it looks like this is trying to do, it would be invalid because the federal law.
And how is it not a First Amendment abridgment as well? You know, I want to speak these notes. Let me speak these notes. And, if I can't do that, that's help me, help. I'm being repressed.
Well, this is not the first instance of repression that has gone on this week in the world of the nation's universities. Over at Syracuse University Law School, apparently there was a blog that was put out there purely as satire. It was saying some funny yet not very nice things about people in the law school, saying which law students were. It sort of harkens back to the Social Network, hot or not kind of questions, and much more funny than that, though. And lo and behold, the university has cracked down on it. And the funny thing about the site, too, is it was a WordPress blog, and they had checked the box. I don't know if they checked the box to make it private or just to keep it out of search engines. But one way or the other, it was intended for purely the law student audience there at Syracuse. But the university has gotten involved. It's doing an investigation. It's accused one of the students as being the author, and he's denying it so far and making all sorts of claims about how his First Amendment rights, or the author, whoever it may be, their First Amendment rights are being abridged by the university here. Is this something that, we're just going to see more and more of as there are more outlets available, be it Twitter or a blog or a website, where someone can poke fun and have a back channel and possibly tick some people off? What do you think, Matt?
Well, I guess yes. I mean, I think that there's probably a lot more of this coming with respect to blogs, especially. I guess the big issue here would be whether or not there's some sort of, is it being run through the university system, their networks?
No, it's on WordPress.
So I guess if it's a private university versus public, and there has to be, if there's some sort of additional First Amendment problems that are going to go along with that. But I could see it happening more often. I guess it'll be interesting to see some of this actually come to a head, to the point where they can hash out some of the law on it, and what the limitations are in light of some of their First Amendment rights for posting these comments, no matter how satirical they are.
So there's the Foundation for Individual Rights in Education has a lengthy and somewhat scathing post on this, and they're attacking the university for describing the website as designed to be offensive. Some, I guess, female students have complained of harassment and, I guess, violations of various academic behavioral standards. And let's see, it's the faculty member investigating the case who's making some rather stringent remarks about the blog. And Fire says, are Fire and Jermaine reading the same site? the one with a blog post that cited burrito chain Chipotle's role in providing postgraduate employment figures for the law school, and with a post that declared a beer bong named Pump Kim the president of Sukol's TWiL class. So, I mean, it seems like these people are just having some fun. But
well, it sounds like the onion within a small ecosystem is what it sounds like.
Mm-hmm. Right. Yeah, the wrinkle here, too, is I guess Syracuse University is a private university, so you get into, whether they have a greater ability to police these sorts of actions by students than a state or public university would. And then finally, before we leave the world of academia and websites and blogs that people are making a splash with, a Boston University student in a sign of the times has looked at his prospects for future employment, decided there are none, decided there's really no reason for him to finish out his term there, and has written an open letter to the dean that he wants his money back. So I guess that's one way of going about it. Nobody's trying to take that one down, though. It's just, I think, sort of a sad commentary on the state of our profession at the moment and the prospects for those in law school.
Could have been convenient afterthought after getting the grades back for the semester, too.
Yeah. Refund, please. Yeah, I don't think they really do that, unfortunately. Some scathing comments to that, the poor guy. I guess his wife is expecting, and somebody said, I feel for your wife. In a few months' time, she'll have 2 crying babies on her hands. All right, so enough of that. We have some final news items of the week. We have Jamie Thomas going back to court for her 3rd time's the charm trial. Ben, what do you think? Is there anything new on the horizon as they go back and try and get the damages right in this RIAA infringement case?
I mean, the only thing new on the horizon that I can think of is Judge Gertner's opinion a few months ago in the Joel Tenenbaum case, which came to essentially the same conclusion that the judge did in the Jamie Thomas case, that the damages were too high. But Judge Gertner relied on constitutional grounds. And there was a rumor that the judge in this case was also considering changing his opinion to rely on the constitutional grounds so that there could just be an appeal as opposed to going through yet a 3rd trial. And I'd like to point out that I think the first time I was on this show back in February, we were talking about this exact same issue because the last verdict and the remitted order came down in February. So it's been, 9 months that this has been just sitting around waiting to get its 3rd trial. It's really just dragging on too long.
Yep, absolutely. Evan, any thoughts?
This is of, paramount importance to our national security and all of this stuff and the future of copyright law. Let's get this trial going and let's, commit all the resources of our judicial system so that this time the record industry can get, $7 million. Let's just do what we can for them. I don't know. Yeah. I mean, it's silly. I mean, come on, seriously. But I guess if history is any indication, we will see a larger verdict for the record companies, because didn't this wasn't the second verdict larger than the first, and so we should expect some kind of curve here. And so maybe we'll either see a remitted or due process claim bring it down even lower. So I don't know.
So are we supposed to fear the random nature of the person they picked? I mean, it's always baffled me how they came to actually pick this person out of the many they could have to prosecute.
Yeah, well, heaven forbid she stand up for herself.
It's not like the RIAA hasn't already said that they're not going to do this anymore. So at this point, they've admitted that this whole process was a failure. So what are they trying to prove at this point? They've thrown tons of money into this case.
A lot of investing in this failed process going on here.
Yeah.
All right. And then also new this week is the U.S. Supreme Court has granted cert in a case involving inducing patent infringement. And Matt, can you describe what's going on there? How do you induce patent infringement, first of all, and what's up with this case?
Well, it's actually I think it's going to become more and more common. What happens is you have 2 forms of you have two ways of proving infringement, essentially direct infringement and indirect infringement. And under direct infringement, which is kind of what you would normally think of, you'll have somebody who actually is the manufacturer of the infringing product or something of that nature. And it's easy to prove. You know, they do steps A, B, and C. They infringe. What you have with indirect infringement is a way for you to for instance, you have a manufacturer that does A, B, and C, but then the end user might be out there actually performing step D. And you need to, so you're not showing direct infringement by the defendant in the suit. You have to go out, you have to make a leap and connect in the activities of somebody else. And to do that, you have to show, and under this direct infringement for inducement, you have to show that there is an intent by this defendant to actually induce that third party to conduct that last step. So it can be complicated, and the real issue comes down to whether or not the alleged infringer, the defendant in the case, knew or should have known that what he was making or what he was putting out there was inducing somebody else to complete the infringement, essentially. So this might come up with, for instance, in something like the touch features in the Apple and the iOS systems, where the actual hardware and everything is easy to show in some, you know, in Motorola or HTC or wherever it is, but then the actual, you know, the actual thing that's occurring, the method of pinching to zoom or some other feature really occurs at the consumer level. So what you have to do is you have to show that the Motorola or HTC, in this example, knew that they were inducing this infringement to prove that the entirety of the patent claim was infringed. You have to make this leap. So the problem with that is, how do you show the intent? And I'll be honest with you, the cases I've been involved with in the past were pretty easy to show, because what happens is you have to create brochures, instruction manuals, things that make it very clear that you're showing this third party how to use this product, and therefore you obviously knew they were going to infringe. So
it's the end user's infringement that's at issue here.
It can be. It can be a customer. It can be an end user. It's generally what it's doing is it's outside of what the defendant in the case. It's outside of the various things they're doing. So you have this missing piece of the patent claim that you have to prove up as the patent owner that is infringed, and sometimes you have to go outside the defendant to do that. So you're showing that the patent holder or the defendant has induced infringement, instructed others, either expressly or I guess it could be less expressed to infringe. So what happens is it's really difficult sometimes in certain cases, I suppose, to show the intent that the patent. I mean, I keep saying that the defendant had to induce others to infringe. So I guess the idea here is that the Supreme Court wants to look at it and clarify it in more definitive terms what the patent owner has to prove in order to establish that this other stuff that's going on outside the defendant, the infringing actor's presence, essentially, is tied back to that infringer.
All right. Well, we appreciate the explanation there. We'll look for that from the Supreme Court. We have now our tip of the week for you, and that is we've actually managed to find a document that has come out of copyright, that the term of its copyright has actually expired, and that would be the Dead Sea Scrolls. They apparently are old enough that the Sonny Bono Copyright Act has actually run its course, and Google can scan them and make them available for your searching convenience and pleasure. So that's our tip, that you can now search the Dead Sea Scrolls in Google. No one, as far as I know, has yet threatened to sue them over this, so I'm going to go ahead and make the pronouncement. Copyright has expired in those things. Anybody want to take me on that? Evan?
Well, what about translations of those copyrights? Would a translation of the scrolls rather could still be copyrighted, especially if it contained commentary or
That's right.
explanations of what the
Google's probably not going to scan them in Sanskrit.
Yeah.
That's what I'm thinking.
They were written in Sanskrit?
I believe.
More awesome than I thought.
Yeah. So our resource of the week also comes to us thanks to Mike Masnick, who featured it over at Tech Dirt. It's not so much a resource, it's something a little bit more fun. A fellow named Dan Bull, who is a rapper, he sounds like a British rapper, has done a video called The Death of ACTA. And it is both funny and freely licensed for us to play here for you. So, Burke, if you wouldn't mind, let's play a bit of that now. Dan Bull, Death of ACTA. Burke.
Only rapper can be called a thief without stealing. Download an MP3 for free. These people hit the ceiling.
Oh, yeah.
The citizen that's teaching you a lesson for restricting my freedom of expression. How can ideas be possessions when they're freely replicable? Hence, unapplicable property laws are reprehensible. Didn't Jefferson express his opinion on the matter when he said invention shouldn't be given a patent? What happened to that thinking? We're stuck in a pattern where the people with everything are keeping everything from us who haven't. We want it back. Look, fed up of adverts.
All right. Thank you, Dan Bull. Thank you, Burke, for queuing that up for us. It's really fun. Mike Masnick has all the lyrics over at Tech Dirt, and I believe that Dan actually posted another version that has the lyrics in the lower third of the video, so you can follow along and sing along. It's quite a nice work there.
It's also great that a guy with a British accent is citing Thomas Jefferson. You know, isn't that ironic if you think about it long enough?
Absolutely. Yes, it's a very erudite piece overall. So with that, folks, we're going to go ahead and wrap it for this week. Thanks so much for joining us for your first time on the show, Matt. We really appreciate your insights and explanations about the ins and outs of patent law and Apple and everything else.
That was enjoyable. Thanks for having me.
Our pleasure. Folks can follow Matt on Twitter at, iVaporAZ.
Yep.
Did I get that right? iVaporAZ
right.
on Twitter. And your Some IP Law, which I really like. It has a nice ring to it for a law firm name for your practice. So I really appreciate your coming on with us, and have a great weekend.
Thanks. You too. It was fun.
And Ben Snitkoff, great to have you back on. I'm sorry it's taken a whole 9 months to have you back. Or actually, you were on once.
I was on in August. It's only been 2 months since the last time. Yeah,
that's right.
But as always, great to be here, and thanks for inviting me back.
Yes, it's wonderful to have you back. And please say hello to David at technicallylegal.org. I think we're going to try and have him back on the show again soon too. And folks, if you like this podcast, definitely go check out Ben and David's podcast over at technicallylegal.org. And Evan Brown, really wonderful to see you again. You got to get out and see this movie, dude. I don't know what to tell you.
I will.
Park your kids somewhere.
Okay.
All right.
Yeah. I mean, we are always looking for good babysitters, so we'll step that up. We'll get into the game.
Good. Yeah, I don't recommend bringing them along with you. It's a little dark for them.
Yeah.
You want them to have some hope and aspiration as to their
I want them to be creative and entrepreneurial. Isn't that what comes out of all this stuff? I don't want to stifle that. We gotta bring that up. So
that's right. So folks, go find Evan between shows at internetcases.com, and he is Internet Cases on Twitter. And over there on our happy Twitter service, I'm D. Howell, and you guys can get in touch with me at Denise at twit.tv. Let me know what's on your mind between shows. Go over to our Facebook page at facebook.com/thisweekinlaw. Check out the questions we post there before the show. We love to get your feedback and incorporate them. So that's it for This Week in Law for Friday, October 22nd. My mom's 70th birthday. Happy birthday, Mom.
Hey, right on. Happy birthday.
Take care, everybody.
Happy birthday.
Bye-bye.
Amateur producers using nuclear samples to advance the legacy of the artists that inspire them. I'm just a citizen that's teaching you a lesson for restricting my freedom of expression.
The pirate hook really makes that music video.
It does, doesn't it? He's really on a pirate ship, too.
to tell us that we should hang on the gallows of law, so we wouldn't even need to have a gallows report. Oh, and by the way, the freaking gallows support is made of signatures which have been apparently forged. This shit is sinister and cannot be allowed to enforce. So tell your ministers and MEPs and
Thanks all. We'll see you next week.
Right on. See you around.